The air inside the courtroom was thick enough to taste. Every shuffle of paper, every creak of the wooden benches seemed amplified, as if the room itself knew something historic was about to happen. Slow, deliberate, almost imperceptible, Judge Amul Thapar leaned forward from the bench. His gaze locked on Jasmine Crockett, not with the cold detachment of a jurist weighing testimony, but with the sharp, searching eyes of a man who had just witnessed something he could not ignore. "Congresswoman," he said, his voice low but carrying to every corner of the chamber, "that was extraordinary." The words hung in the air like a struck bell, reverberating through the silence. For a heartbeat, no one moved. Then, as if on cue, the gallery erupted, a swell of applause breaking the rigid decorum of the court. Some clapped cautiously, others with unrestrained fervor, but all of them knew they had just seen something rare. A moment when skill, truth, and courage cut clean through the fog of partisanship. Freeze that frame, hold it. The conservative federal judge, appointed by a Republican president, openly commending a progressive firebrand from Texas, a woman whose politics on paper could not be further from his own. This wasn't supposed to happen. Not here. Not like this. But it did. And the question that now burned in every mind in that courtroom, in the newsrooms already drafting headlines, in the millions who would soon watch the clip online, was simple. How? How did a first-term Congresswoman, often dismissed by her opponents as too brash, too uncompromising, command the respect of one of the judiciary's most formidable conservative thinkers? How did she turn a setting designed to intimidate into a stage for one of the most precise, devastating legal arguments in recent memory? What you're about to see is not just a courtroom exchange. It's a masterclass in turning the tables, in using preparation, intellect, and moral clarity to dismantle the very assumptions meant to box you in. And yet, this moment didn't come out of nowhere. It was forged in the heat of a case that carried the weight of history, in a clash where the stakes were nothing less than the definition of American democracy itself. To understand why this moment shook the legal world, we have to go back to where the tension began. The case had already been called the trial of the decade before the first witness was sworn in. News vans lined the streets outside the courthouse, their satellite dishes pointed skyward like steel sunflowers. Inside, the air was taut with expectation. This wasn't just another legal dispute over district maps or ballot access. This was a direct challenge to the very heart of the 15th Amendment, the constitutional promise that no citizen's right to vote shall be denied or abridged on account of race. The plaintiffs argued that a newly enacted state law, cloaked in the language of election integrity, was in fact a calculated effort to suppress minority turnout. The defense insisted it was a neutral safeguard, a necessary measure to protect against fraud. But beneath the legal jargon, everyone knew what was really at stake, whether the hard-won protections of the civil rights era would be fortified for a new generation, or quietly hollowed out under the weight of technicalities. Jasmine Crockett stepped into the courtroom knowing the odds were stacked against her. The bench was skeptical, not overtly hostile, but wary of what they saw as a political crusader in legal robes. Opposing counsel, a seasoned litigator with a reputation for cutting down witnesses before they could finish a sentence, had already made it clear in pre-trial motions that he intended to paint her as an ideologue, not a serious legal mind. But Crockett had been here before, in spirit if not in scale. She had faced down dismissive smirks, condescending interruptions, and the quiet, calculated underestimation that so often greets women of color in the halls of power. She knew the sting of being told in words or in tone that she was out of her depth, and she knew exactly how to turn that sting into fuel. The ideological divide in the room was palpable. On one side, those who saw the law as a shield for democracy. On the other, those who saw it as a weapon to be wielded in the name of order. The arguments weren't just about statutes and precedents. They were about the soul of the nation. Every person in that chamber, from the stenographer to the spectators in the back row, could feel it. This wasn't just law. the narrator's voice would later echo over the footage. It was America's identity on trial. And the stakes reached far beyond the courtroom walls. A ruling in favor of the plaintiffs could set a precedent that would ripple through every state considering similar legislation, reinforcing the constitutional guardrails against racial discrimination in voting. A loss could embolden lawmakers to push the limits further, confident that the courts would look the other way. Crockett's opening statement would have to do more than outline her case. It would have to pierce through the skepticism, dismantle the caricature her opponents had drawn, and remind the court and the country that the right to vote was not an abstract principle, but a living, breathing promise. She adjusted her notes, feeling the weight of the moment settle on her shoulders. Somewhere in the gallery, cameras clicked softly, capturing the stillness before the storm. The bailiff's voice rang out, calling the court to order. But before the first gavel strike, the man she would face had a history that made this battle even more daunting. To understand the weight of what Jasmine Crockett was walking into, you have to know the man presiding over the bench that day. Judge Amul Thapar was not just another federal judge in a black robe. He was a towering figure in conservative legal circles, a jurist whose name had been floated more than once for the Supreme Court. Born to immigrant parents from India, he had carved his way into the upper echelons of the judiciary through a combination of relentless discipline, intellectual rigor, and an unshakable belief in the originalist interpretation of the Constitution. Originalism to Thapar wasn't just a legal theory, it was a creed. He believed the Constitution meant what it meant when it was written, and that the role of a judge was not to bend its words to modern sensibilities, but to anchor them in the intent of the founders. To his admirers, this made him a guardian of stability and restraint. To his critics, it made him an obstacle to progress. But even those critics would admit, often grudgingly, that Thapar's mind was a steel trap. In the courtroom, he was known for his surgical questioning. He didn't raise his voice. He didn't grandstand. Instead, he dismantled arguments with the precision of a watchmaker taking apart a timepiece piece by piece, until the whole mechanism lay exposed and useless. Progressive lawyers who came before him often left with their cases in tatters, not because he shouted them down, but because he found the one loose thread in their reasoning and pulled until the whole thing unraveled. There was the environmental case in 2018, where a young attorney argued for expanded federal protections under the Clean Water Act. Thapar listened patiently, then asked a single question about the statutory definition of navigable waters. The lawyer stumbled, tried to pivot, and within minutes, the judge had walked him into conceding that his interpretation would require rewriting the statute entirely. The ruling that followed was a decisive loss for the plaintiffs. Or the high-profile free speech case in 2020, where a civil rights group sought to challenge a state law they claimed chilled political expression. Thapar's cross-examination of their lead counsel became a cautionary tale in legal circles. He didn't just poke holes in their argument. He exposed contradictions in their own cited precedents, forcing them to admit, on record, that their position conflicted with earlier rulings they themselves had championed. These moments weren't anomalies. They were the pattern. Lawyers who entered his courtroom without airtight reasoning were, in the words of one legal commentator, bringing a knife to a gunfight. And yet, Thapar was not a man without respect for skill. When an attorney came prepared, when they could meet him point for point, he was known to acknowledge it, sometimes with a nod, sometimes with a carefully chosen compliment. But those moments were rare, and rarer still when the attorney came from the progressive side of the ideological spectrum. That was the mountain Jasmine Crockett was about to climb. She knew his record. She had watched the footage of him methodically cornering attorneys until their arguments collapsed under their own weight. She understood that in his courtroom, there was no room for rhetorical flourish without substance, no tolerance for appeals to emotion without constitutional grounding. And yet, there was something else, something that made this confrontation even more charged. Thapar's own story, as the son of immigrants, intersected in unexpected ways with the case before him. The 15th Amendment, the right to vote, the question of who gets to fully participate in the American experiment, these were not abstract issues for someone whose family had once been outsiders to the system. But Thapar's judicial philosophy demanded that personal history take a back seat to the text and structure of the law. For Crockett, that meant threading a needle. She would have to build an argument so rooted in constitutional fidelity that it spoke to his originalist instincts, while also carrying the moral force of the communities whose rights were on the line. It was a high-wire act with no safety net. The legal world was watching. Commentators whispered that this was a mismatch, that Crockett's style, passionate, unapologetically progressive, would clash with Thapar's disciplined, textualist approach. Some predicted she wouldn't last 10 minutes before he found the weak seam in her case and pulled it apart. But Crockett had no intention of being another cautionary tale. She had studied his rulings, dissected his questions in past cases, and built her strategy not to avoid his scrutiny, but to invite it, to meet it head-on and turn it to her advantage. Because while Thapar was the mountain, Jasmine Crockett's journey had prepared her to climb it. Long before Jasmine Crockett's name was spoken in the same breath as landmark cases and courtroom applause, she was a young girl in a neighborhood where opportunity was something you fought for, not something handed to you. Her earliest memories were of watching her mother work double shifts, her father fixing cars in the driveway to make ends meet, and the quiet, unspoken understanding that if you wanted a seat at the table, you had to build the chair yourself. School was where she first learned the art of holding her ground. Teachers noticed her sharp mind, but also her unwillingness to let injustice slide, even in small things. When a classmate was unfairly disciplined, she was the one who asked why. When a teacher dismissed a student's accent as broken English, she was the one who challenged it. Those moments didn't win her popularity with authority figures, but they planted the seeds of a career built on speaking truth to power. Her path to law wasn't a straight line. There were moments when the weight of bills, family responsibilities, and the constant hum of doubt threatened to pull her off course. She worked part-time jobs through college, often studying in the back room of a diner after closing shifts. There were nights she wondered if the dream was too big, if the system she wanted to change would ever let her in. But there were also voices that kept her moving forward. A high school civics teacher who told her she had the mind of a litigator. A college mentor who slipped her a worn copy of the Federalist Papers and said, "Understand this, and you'll understand how to beat them at their own game." A legal aid attorney who let her shadow him in court, showing her that the law wasn't just theory, it was a weapon, and in the right hands it could protect the vulnerable. Law school sharpened her instincts. She wasn't the loudest in class, but when she spoke, people listened. She learned to dissect statutes like puzzles, to anticipate counterarguments before they were spoken. Her professors noted her meticulous preparation, the way she could cite precedent from memory, the way she could weave constitutional principles into real-world narratives that juries could feel in their bones. When she entered practice, she didn't chase corporate clients or high-paying firms. She went where the fights were hardest, defending tenants against unlawful evictions, representing workers denied fair wages, standing beside families whose voting rights had been trampled. In cramped offices and underfunded courtrooms, she built a reputation for fearless advocacy. She didn't just argue cases, she embodied them. Voting rights, in particular, were not an abstract legal concept for her. They were personal. She had seen elders in her community wait hours in line to cast a ballot, only to be told they were at the wrong precinct. She had watched as new laws quietly closed polling places in neighborhoods that looked like hers. She knew the stories of those who had marched, bled, and died for the right to vote, and she carried those stories into every brief she wrote, every motion she filed. There were setbacks, of course, cases she should have won but didn't, judges who dismissed her arguments before she could finish them, opposing counsel who underestimated her until they realized too late that she had outprepared them. Each loss stung, but each one also taught her something about resilience, about strategy, about the long game. Her style evolved into a blend of precision and passion. She could quote constitutional text with the best of them, but she could also look a judge in the eye and make them feel the human cost of a legal decision. She learned that the most powerful arguments weren't just airtight in logic, they were unshakable in moral clarity. By the time the voting rights case that would put her in Judge Thapar's courtroom landed on her desk, she was no stranger to uphill battles. But this one was different. The stakes were national, the opposition was formidable, and the judge, well, she knew his reputation. She knew he could dismantle an argument with a single question. So she prepared like never before. She read every opinion he had written, every dissent, every concurrence. She studied his cadence in oral arguments, the way he framed his hypotheticals, the precedents he returned to again and again. She built her case not just to survive his scrutiny, but to speak directly to the principles he claimed to hold most dear. Still, in the quiet moments, late nights at her kitchen table, briefs spread out like a battlefield map, doubt crept in. What if she failed? What if this case became another cautionary tale about progressive lawyers overreaching? But then she would think of her constituents, of the elders who had trusted her to fight for their voice, of the young voters who believed the system could still work for them. And the doubt would burn away, replaced by resolve. She wasn't just walking into a courtroom to argue a case. She was walking in to defend a promise, one written into the Constitution, paid for in blood, and too often treated as negotiable. And so, when the day came, she walked into that courtroom with more than just legal briefs. She carried the weight of history. The first question came like a scalpel. "Congresswoman," Judge Thapar began, his tone measured, "if the framers of the 15th Amendment intended to prohibit all forms of voting regulation, why did they leave the states with the authority to determine the manner of elections?" It was the kind of question designed to corner, to force a concession that could unravel an entire argument. The defense counsel leaned back in his chair, a faint smirk tugging at the corner of his mouth. Crockett didn't flinch. "Your Honor," she replied evenly, "the framers also understood that the authority to regulate could never be used as a pretext to discriminate. The text is clear. The right to vote shall not be denied or abridged on account of race. The manner of elections is subordinate to that guarantee, not a loophole to evade it." A murmur rippled through the gallery. Thapar's eyes narrowed slightly, not in hostility, but in focus. He pressed again. "But how do you distinguish between legitimate regulation and unconstitutional suppression without granting the courts a power the Constitution never explicitly provides?" Crockett's voice was steady, her cadence deliberate. "By applying the same test the court has used for over a century, examining intent, effect, and historical context. The Constitution may not list every form of discrimination, but it gives us the principle. The judiciary's role is to ensure that principle is not hollowed out by clever drafting." The smirk on opposing counsel's face faltered. He scribbled something on his legal pad, his pen tapping faster than before. Thapar shifted in his seat, his questions coming faster now, each one a probe into the structural limits of federal oversight, the boundaries of state sovereignty, the weight of precedent. Crockett met each one with precision, citing cases by name, year, and holding, weaving them into a narrative that was both legally airtight and morally resonant. The defense tried to interject, objecting to her framing, but the judge waved them down. "I'll allow her to finish." That was when the tension in the room began to change. The early confidence from the defense table was giving way to something else, a quiet, growing frustration. Their narrative, carefully constructed to cast Crockett as an overreaching partisan, was slipping out of their control. Every time they expected her to stumble, she answered with a clarity that left no opening to exploit. In the gallery, people leaned forward in their seats. Some clutched the edges of the benches, others exchanged quick glances as if to say, "She's holding her own." The air was thick with the unspoken realization that this was no ordinary exchange. This was a duel not of volume, but of intellect. Thapar's next question was almost a challenge. Congresswoman, are you suggesting that the court should weigh the lived experiences of voters alongside the text of the law? Crockett didn't hesitate. I'm suggesting, Your Honor, that the text of the law was written to protect those lived experiences. The words mean nothing if they are divorced from the reality they were meant to safeguard. A few heads in the gallery nodded. Even some of the court staff seemed momentarily still, their pens hovering above their notepads. The defense counsel's frustration was now visible, a tightening jaw, a restless shuffle of papers. He tried to regain ground, launching into a procedural objection, but it came off rushed, almost desperate. Crockett simply waited, hands folded, until the judge gestured for her to continue. And continue she did, with a quiet authority that made it clear she was not here to survive the questioning. She was here to own it. Each answer was a brick laid in a wall that the defense could not scale. Each citation was a reminder that she had not only anticipated these questions, she had built her case around them. By now, the whispers in the gallery had grown more frequent, though still hushed. People were reacting not just to the substance of her answers, but to the composure with which she delivered them. This was the kind of performance that turned skeptics into believers, that made even ideological opponents take notice. The defense counsel glanced at the clock, as if willing the minutes to pass faster, but time was not on his side. The momentum had shifted, and everyone in the room could feel it. And then came the moment that would silence the room and change the tone of the trial forever. For a moment the courtroom was still, the kind of stillness that comes not from peace, but from the coiling of tension before it snaps. Crockett stood at the lectern, her fingertips resting lightly on the edge, eyes fixed on Judge Thapar. She didn't rush. She let the silence breathe, let the weight of the previous exchange settle into the minds of everyone present. Your Honor, she began, her voice low but steady, I'd like to answer your question by going back not to the last decade, not even to the last century, but to the very moment the Reconstruction Amendments were conceived. She reached for a bound volume on the table beside her. The leather was worn, the pages yellowed, a reproduction of the Congressional Globe from 1866. She opened it slowly, deliberately, as if inviting the entire room to lean in. In the debates over the 15th Amendment, she continued, Senator Henry Wilson of Massachusetts said, and I quote, "We are here to secure to the humblest citizen, without regard to race or color, the full and equal enjoyment of political rights." She looked up, meeting Thapar's gaze. Not partial enjoyment, not enjoyment subject to the clever drafting of state legislatures, full and equal. A murmur rippled through the gallery. She let it pass, then turned a page. And when opponents argued that states should retain the power to impose neutral qualifications, Representative John Bingham, the principal framer of the 14th Amendment, warned that such power, if unchecked, would be used to perpetuate the very inequalities this nation has shed blood to destroy. She paused again, letting the words hang in the air. The defense counsel shifted uncomfortably, his pen tapping against his legal pad. Your Honor, she said, her tone sharpening, these are not my words. They are the words of the framers themselves, the men whose intent you have sworn to honor through originalist interpretation. They understood that the right to vote was not a gift from the states, but a guarantee from the nation. And they understood that any law, no matter how artfully written, that undermines that guarantee is an affront to the Constitution itself. Thapar's expression was unreadable, but his eyes had narrowed not in skepticism, but in concentration. Crockett pressed on. The defense would have you believe that this law is neutral, but neutrality is not measured by the ink on the page. It is measured by the impact in the real world. And the real-world impact here is clear: disproportionate disenfranchisement of minority voters. That is not conjecture. That is fact, supported by the state's own data. She slid a document across the table toward the clerk, a statistical analysis showing the racial breakdown of voters affected by the new restrictions. When 70% of those turned away share the same racial identity, we are not looking at coincidence. We are looking at the very evil the 15th Amendment was written to prevent. The defense counsel rose to object, but Thapar raised a hand. Overruled, continue. Crockett nodded once, then leaned in slightly, her voice dropping just enough to draw the room closer. Your Honor, I know your record. I know you have written that the Constitution must be interpreted as it was understood at the time it was ratified. I agree. And at the time the 15th Amendment was ratified, its authors understood that states could not be trusted to police themselves when it came to racial equality in voting. That is why they placed this protection in the Constitution, to bind the hands of those who would use state power to silence certain voices. She let that sink in, then delivered the pivot. So I am not asking you to adopt a new doctrine. I am asking you to apply your own faithfully, fully, and without compromise. Because if originalism means anything, it means honoring the original purpose of the text, not just its letters. There was a subtle shift in Thapar's posture, a slight leaning back, a softening of the jaw. It was the kind of change only those watching closely would notice, but it was there. Crockett reached for one final piece of evidence, a letter from a black Union veteran, written in 1870, pleading with Congress to enforce the new amendment after his neighbors were barred from voting. She read it aloud, her voice steady but carrying an undercurrent of emotion. We fought for this Union, we bled for its flag, and now we are told our voices do not count. If this is liberty, then it is liberty in name only. She closed the letter and looked directly at Thapar. Your Honor, the men who wrote these words are gone. The men who framed the 15th Amendment are gone, but the promise they made is still here, and it is this court's duty, your duty, to keep it. For a heartbeat there was silence. Then Thapar leaned forward, his hands clasped. Congresswoman, he said, his voice carrying the weight of the moment, that was extraordinary. It wasn't a challenge. It wasn't a concession. It was something rarer, respect. The gallery erupted. Applause broke out, first in scattered bursts, then swelling into a wave that filled the chamber. Some stood, others clapped from their seats, but all of them knew they had just witnessed something remarkable. A progressive firebrand turning the very tools of her ideological opposite into the foundation of her victory. The defense counsel sat frozen, his pen still in his hand, as if unsure whether to keep writing or simply accept the inevitability of what had just happened. Crockett didn't smile. She didn't gloat. She simply stepped back from the lectern, her hands resting at her sides, the echo of the applause washing over her. Because she knew this was more than a good day in court. This was a moment that would ripple far beyond these walls, a moment that proved preparation, principle, and moral clarity could still cut through the noise. But the shockwaves didn't stop at the courtroom doors. The applause in the courtroom had barely faded before the first clips hit the internet. A shaky phone recording from the gallery, posted within minutes, captured the exact moment Judge Thapar leaned forward and uttered the words that would ignite a firestorm. That was extraordinary. By the time Crockett stepped out into the crisp afternoon air, the video had already been shared thousands of times. Within an hour, hashtags began to bloom across platforms. Extraordinary Crockett, originalism turned voting rights victory. On progressive Twitter, the clip was hailed as a masterclass in legal judo, with users marveling at how she had used Thapar's own judicial philosophy to dismantle the defense. But it wasn't just her base that was talking. Conservative commentators, some visibly begrudging, admitted on air that her argument had been impressively airtight. Cable news producers scrambled to book her for primetime interviews. The Chiron writers had a field day. Progressive Congresswoman wins praise from conservative judge. Courtroom applause breaks decorum and the internet. On one panel, a former federal prosecutor shook his head in disbelief. You don't see this, he said. Not in this climate, not in this court. The virality wasn't confined to political junkies. Law students across the country began dissecting the exchange in group chats and study sessions. Professors at two prominent law schools announced they would be adding the transcript to their constitutional law syllabi, citing it as a rare, modern example of originalist reasoning deployed in service of civil rights. One professor tweeted, "This is how you argue across ideological lines, with respect for the framework, but mastery of the facts." In community centers and coffee shops, people watched the clip on their phones, some replaying the moment over and over. For many, it wasn't just about the legal victory. It was about seeing someone who looked like them, who spoke for them, command the respect of a system that so often dismissed their voices. Emails and messages poured into Crockett's office. A retired schoolteacher from Georgia wrote, "I've been voting since 1965 and I've never felt so seen in a courtroom." A young law student from California said, "I was thinking of dropping out. Watching you today reminded me why I started." A veteran from Ohio, who admitted he didn't share her politics, wrote simply, "You argued with honor. That matters." Even late-night comedians got in on the moment, replaying the clip with mock instant replay graphics, freeze-framing Thapar's subtle shift in expression before delivering his praise. The laughter was affectionate, not derisive, a sign that the moment had transcended partisan sniping and entered the realm of shared cultural touchstone. The defense team, meanwhile, found themselves on the defensive outside the courtroom. Reporters peppered them with questions about whether they had underestimated Crockett. Their answers were clipped, their smiles tight. The narrative had slipped from their grasp, and no amount of spin could erase the image of their case unraveling under her steady hand. In the days that followed, the clip's reach only grew. Activist groups used it in fundraising emails, framing it as proof that the fight for voting rights was far from over and winnable. Editorial boards weighed in, some praising the intellectual rigor of the exchange, others warning that one moment of bipartisan respect didn't erase the deep divides in the country. But even the skeptics acknowledged the rarity of what had happened. For Crockett, the whirlwind was both exhilarating and exhausting. She fielded interview requests, spoke at rallies, and answered questions from reporters who wanted to know if this was the start of a new chapter in her career. She deflected the speculation, steering the conversation back to the case, to the voters whose rights hung in the balance. And yet, beneath the noise, there was something quieter happening, something that mattered more to her than the trending hashtags or the television hits. In neighborhoods across her district, people were talking about the Constitution. They were debating the meaning of the Reconstruction Amendments, asking questions about originalism, connecting the dots between history and the present. For a brief moment, civic engagement wasn't an abstract ideal. It was alive, urgent, and personal. The applause in that courtroom had been the spark. The shockwaves were the proof that it had caught fire. And yet, for Crockett, the real victory wasn't applause, it was something far deeper. Long after the cameras stopped rolling and the courthouse steps had emptied, Jasmine Crockett found herself alone in her office, the day's events replaying in her mind. The applause, the headlines, the flood of messages, they were gratifying, yes, but they weren't the essence of what had happened. What stayed with her was the look in Judge Thapar's eyes when he spoke that single word, extraordinary. It wasn't agreement. It wasn't surrender. It was recognition, the kind that transcends politics, the kind that says, "I see the merit in what you've done." She knew how rare that was in today's climate. In an era where ideological lines are drawn like battlefronts, where every exchange is filtered through the lens of partisanship, moments of genuine respect are almost extinct. And yet, here it was a proof that truth, skill, and preparation could still pierce the armor of division. Crockett leaned back in her chair, thinking about the people who had reached out in the hours since the ruling. The retired teacher who had fought for desegregation in her youth, the law student who had been on the verge of quitting, the veteran who admitted he didn't share her politics but respected her argument. These weren't just compliments, they were reminders that the work mattered beyond the win. This is what it's supposed to be, she thought. Not about humiliating the other side, not about scoring points for the cameras, but about service, about making the law serve the people it was written for. The narrator's voice would later frame it for the audience. In that courtroom, Crockett didn't just defend a case. She defended the idea that dignity is stronger than division, that service is greater than ego, and that the Constitution belongs to all of us, not just those who interpret it in our favor. It was a lesson rooted in the very fabric of the American experiment. Justice is not the property of one party. Equality is not a partisan slogan. Courage is not reserved for those who agree with us. These values are the inheritance of every citizen, and they demand guardians who will protect them even when it's inconvenient, even when it's unpopular. Crockett understood that the victory was not in changing Thapar's ideology. That was never the goal. The victory was in showing that the space between opposing worldviews is not always empty. Sometimes, it can be bridged by a shared commitment to the integrity of the law. She thought of the young people watching, the ones who had been told that politics is nothing but noise and corruption. Maybe, just maybe, they had seen something different today, a glimpse of what it looks like when the system works as it should, when adversaries meet on the field of ideas and leave with mutual respect. The applause had been loud, but the real resonance was quieter, deeper. It was in the conversations happening at kitchen tables, in classrooms, in community centers. It was in the renewed belief that the law could still be a shield for the vulnerable, not just a tool for the powerful. As the sun dipped below the horizon, casting long shadows across her desk, Crockett closed her eyes for a moment. She thought of the elders who had marched for the right to vote, of the activists who had been jailed for demanding equality, of the countless unnamed citizens who had carried the torch of justice through darker times than these. She felt their presence in the room, a silent reminder that her work was part of something much larger than herself. When she opened her eyes, the resolve was there again, steady, unshakable. Today had been a victory, but it was not the end. The forces that sought to narrow the promise of democracy were still out there, still working. And so was she. The narrator's voice would close the section with a promise to the audience. In a time when cynicism comes easy, moments like this remind us why the fight is worth it. Because dignity is not weakness. Service is not surrender. And truth, when wielded with courage, can still command the respect of those who disagree most. And if you think this was her last stand, think again. The image is still vivid. Judge Amul Thapar leaning forward, the hush in the courtroom, and that single word, extraordinary, breaking the silence. It was the moment that transformed a tense legal showdown into something larger, something unforgettable. From the first gavel strike to the final applause, Jasmine Crockett had done more than argue a case. She had shown in real time that skill, preparation, and integrity are still the most powerful tools in the pursuit of justice. This was never just about one ruling. It was about proving that even in a system often defined by division, there is still room for respect earned through mastery. Crockett didn't win that moment because she shouted the loudest or played to the crowd. She won it because she knew her case inside and out, because she honored the Constitution's promise while speaking to the lived reality of those it protects, and because she refused to let cynicism dictate the outcome. In an age where so much of public life feels like noise, this was clarity. It was a reminder that brilliance, when paired with purpose, can cut through the static and command attention from even the most unlikely quarters. And now, that moment belongs to more than just the people in that courtroom. It belongs to anyone who believes that truth still matters, that preparation still pays off, and that dignity is not a weakness but a strength. If you believe in voices like Jasmine Crockett's, share this story. Let it travel beyond headlines and hashtags. Let it remind others that brilliance should never be ignored, and that when it's met with courage, it can change the conversation, the culture, and maybe even the course of history.